This webinar today, the topic is protection orders, restraining orders, and no contact orders in Washington State, what to get and when. And I'm here today with Michelle Dellino of Dellino Law Group. I will introduce myself briefly. My name is Melissa Rosenberg, and I am a therapist working in private practice, specializing working with clients who are dealing with divorces, separations, relationship transitions. I work with clients in all different stages of that process, early on while they're trying to determine if it's the best route to take during complicated family law cases, and also afterwards, and helping navigate next chapters of my clients' lives. And today I'm here as a moderator for this webinar. And so I'm going to be taking questions and pitching them to Michelle as they come in. You can put them in the Q&A, or you can put them in the chat. So if you put them in the Q&A, if you want to mark yourself as an anonymous member, go ahead and do that. Otherwise, your name will pop up for other people to see who's asking what questions. If you put them in the chat, they'll just come to me and I'll pitch them. So yeah, I am, like I said, a therapist, and divorce and separation is one of my areas of specialty. Today, I'm here to moderate and to field any questions that come in that might pertain to my specialty, but more importantly, to make sure that you guys get the information related to the protection orders of all different types, and that Michelle gets the questions answered that you guys have pressing today. So we will go ahead and get started. I know that Michelle is going to deliver some information. So as we're going through the webinar, if questions come in, go ahead and put those either in the chat or the Q&A. And we'll try to get as many answered as we can. I will let Michelle go ahead and introduce herself, and we'll get this going. Thanks.
Great. Thanks, Melissa. Hi, thanks for being here. I'm Michelle Dellino. I'm the owner and managing attorney of Dellino Family Law Group. We are a family law firm in Seattle and Bellevue. We handle cases all over Washington State. I've been practicing family law for about 14 years. So I have seen pretty much every kind of family law case there is, including dealing with protection orders. I also used to practice criminal defense, and criminal defense deals very often with no contact orders. So today we're going to talk about the differences between protection orders, restraining orders, and no contact orders. We're going to learn a little bit more about those different types of orders, what they mean, when they apply. I find there's a lot of confusion around this. A lot of times people will think, oh, I'm getting a restraining order, and you're really not. You really need a protection order, and the rules are totally different for that than you might think. So anyway, that's a little bit about what we're going to talk about and a little bit about me. I'm going to give you some content and some information. It's important for you to know that the webinar will be recorded and it'll be available later on our YouTube channel. So if you're like, oh, I want to hear what she said and I can't remember, or I didn't write it down, it's all going to be available for you later as well. And then you can, like Melissa said, ask any questions that you might have, if you, whether anonymously or in the public chat, and then she will let me know, because I won't see those when those come in. So what I'm going to start with today is I'm going to start in talking about the very basics between the three types of orders. So what that means is there are protection orders, there are no contact orders, and there are restraining orders. The protection order statute, it governs there's different types of protection orders. So we're going to talk briefly about domestic violence protection orders, which is one of the most common. There were changes to we call them DVPOs as an abbreviation. There were changes to the definition of domestic violence and domestic violence protection orders. There were changes to the laws just this year. So we'll talk about that a little bit. It may look a little different than some of you may remember if you've had experience with these before. There are also anti-harassment orders, and anti-harassment orders are also protection orders. So we'll talk about those. There are those are called AHOs or AHOs sometimes. There are sexual assault protection orders. Those are called SAPOs. That's the acronym there. And we'll talk about when those might apply. And there are also far less common, but there are two other types of orders I will touch on just briefly. An EPO, which is actually, well, yeah, you could just call it an extreme risk protection order is sometimes called an EPO order. Extreme risk protection orders are very rare, and you probably won't need one of those. And then there are what are called VAPOs, vulnerable adult protection orders as well. But the main ones we'll focus on touching on are DVPOs, anti-harassment orders, and sexual assault protection orders. So anyway, that is an overview of protection orders. And you might be wondering, when do I get a protection order? How does that work? Well, a protection order you can get on its own if you think you need to. You can get it as part of a divorce or family law case. If you're initiating a case, you can basically do that at the same time, but you can get it either way. And then another question that comes up in the very beginning is, where do I go to get one of these? Well, Superior Court is what we call a court of general jurisdiction. And that means it handles a lot of things. That's if you file a divorce or a parenting plan modification or anything related to domestic relations, it's going to end up being in Superior Court. Okay. And if you have a protection order and there's kids involved, it's going to end up being in Superior Court. If you have a protection order and there's no kids involved, it could also be in district courts. District courts are what we call courts of limited jurisdiction. That jurisdiction means what the court can enter orders about. So the district courts, there are several around King County. There's several in Snohomish County. Every county has a set of district courts, and you might have things there like protection orders with no kids. You might have, and when there's no family law case, you might have traffic tickets. You might have some criminal misdemeanors. All kinds of things go on in the district courts. And then you don't have protection orders heard in Superior Court unless there's certain criteria that's met. So you can file a protection order. They try to make it accessible and easy for you. That can happen in district court or Superior Court, for the most part. If you go to district court and your case gets transferred to Superior Court, they're still going to let you file it there because it's easy to walk in and do it. So the idea of the protection order statute is to make protection accessible and available to people that need it. When, there might not necessarily be a no contact order from a criminal case, or maybe there's not a criminal case, and maybe you didn't report the domestic violence, but you still need protection. Maybe somebody didn't get arrested, but you still need protection. So in an instance like that, protection orders are a really good avenue for you. So we'll come back and talk about those again in a minute. I want to touch briefly on what is a no contact order, because that's another thing that comes up a lot. People will say, oh, I need to get a no contact order. Well, you don't have the ability to go and get a no contact order on your own. A no contact order is an order that's issued. It's kind of what I call it, a companion order, because it's a companion to a criminal case. You don't get a no contact order unless there's a criminal case. A very common instance would be person A is charged with domestic violence assault or assault of another person. And so as a condition of their release on a criminal case, while that case is pending, the court will issue an NCO or a no contact order, and it'll say one of your conditions about being released while this case is pending is to stay away from the victim. There's a no contact order in place. Or after a case is over, whether it's resolved at trial or through a plea agreement, a no contact order might say, have no contact with this person for 24 months or 36 months. So no contact orders are companion orders that go with criminal cases. We'll touch on them a little bit more, but that's kind of the main thing that I think is important for you to know. And then let's talk briefly about restraining orders, because then we'll come back and start again with protection orders and dive into that a little deeper. Restraining orders are another thing. People will say, oh, I want a restraining order. Well, you might, but you need to know what that means. A lot of the most common crossover is people say they want a restraining order to keep someone away from them. And what they really meant was they wanted a protection order. Restraining orders can keep people away from you, but restraining orders are also what I call companion orders. You can get a restraining order. A restraining order is a civil order, and it's going to be issued like there's different types. There's financial restraining orders. There are restraining orders that restrain the usage of property. There are restraining orders that keep you away from another person. So if you're filing a family law case, here's the first restraining order. Every family law case filed in King County, I shouldn't say family law case, every divorce that's filed in King County is going to have a restraining order in place on finances. Every time you file a family law case, there is an automatic temporary financial restraining order that goes into place that says neither party now can buy, sell, use, encumber property outside of the normal course of business. This is meant to protect the parties. So, for example, I file for divorce and serve everything on my husband, and the next day he goes and moves $40,000 from our savings account to his account. Well, that would be a violation of that order. Or here's another scenario. I file for divorce from my husband. I serve the paperwork on him. And the next day he takes money out and pays the mortgage. That would not be a violation because that's a normal course of usage. So a financial restraining order in a divorce case doesn't stop you from spending money. It stops somebody from draining the account. It stops somebody from going and buying a car tomorrow. You can do those things, but only if you have an agreement. Otherwise, you can't. So that restraining order gets issued in every case. Now let's talk about physical restraining orders that might keep you away from your soon-to-be ex-spouse. So if you filed a case and it was a divorce case, or even if you filed some other kind of family law case, a parenting plan modification or a parentage action, you could seek a restraining order as well. A restraining order would basically say, restrain the other party from coming to my house, restrain the other party from contacting me. It can be liberal as far as what you decide. You can ask for a restraining order that just says, don't disturb my peace, don't create, don't talk to me unless it's about the case. Or you can be saying, don't have any communication, no third-party contact, no in-person contact, nothing while the case is going on. And then you can ask for a restraining order to continue at the end of the case. Sometimes a restraining order is just something that's in place during a case because it's kind of like a cooling thing. Like everybody, tempers are flaring. Maybe somebody sent some text to somebody else they shouldn't have, and somebody feels scared and everybody's upset and emotional. So a lot of the time, if it's warranted, the court will put that restraining order in place to limit contact or to change contact while the case is pending to allow things to sort of stabilize. So that's an important thing for you to understand. There also are times when you get an immediate restraining order. Usually if you're asking for a restraining order in a family law case, you will note a hearing and people will go to court and talk about it. And the court will make a decision, and that hearing is probably gonna be at least 2 weeks away, maybe more. But a very common occurrence with restraining orders is I'm filing for a divorce and I'm not seeking a protection order, but I am worried about what the other party is going to do. They've threatened me. Or it could be a situation where I'm filing a case and I feel my child's in danger if they're with the other parent alone. So I need an immediate restraining order to either keep that parent away from me or keep them away from my child. So you could go to court the very beginning of your case and get what's called an ex parte immediate restraining order, where you go and you ask for an order without the other party having an opportunity to object. And the court then looks at it and says, are there facts here that think we should issue something on an immediate emergency basis? If there are, and irreparable harm is likely to come to someone if they don't do it, they will issue it. And then the other party will come back to a return hearing with you and have an opportunity to basically say why that order shouldn't stay in place and defend on it. But you can get that immediate restraining order issued. It's issued automatically on financials, but it's not going to be issued with respect to contact between the parties or keeping a parent and child apart until the court actually hears from you or your attorney and sees what the facts are that support it. Those are the really common types of restraining orders. So as you can see, protection orders, no contact orders, and restraining orders are all they're really, really different. So let's go back and talk about protection orders, because these are really kind of the most common aside from the temporary financial restraints. And a lot of the time when people say, I want a no contact order, I want a restraining order, what they really meant is a protection order. What it is it's a legal order issued by the court to protect people who are victims of domestic violence, sexual assault, stalking, or harassment for the most part. And the purpose of an order is to keep contact or certain behaviors by somebody who poses a threat or a danger to the person who's seeking the protection. So you have two parties. You have the protected party and you have the restrained party. The protected party is the person who's petitioning and getting the order. The restrained party is the person who is defending, and if an order is entered, then they're restrained. You have to understand a few things, though, about protection orders. You have to meet certain eligibility to actually get one. So to get a protection order, whether it is, especially for a domestic violence protection order, the most common type, you need to have a certain relationship. You need to be a current or former spouse, a former or current domestic partner, have had a dating relationship, or be a family or household member. So if you're roommates, you don't qualify for that. You're not going to be getting a protection order. You're going to be getting a different type of order if you have concerns. But if you were dating this person at some point, then you do qualify because you had an intimate dating relationship. If it's a family or household member, like it's your brother or something, you could get a protection order because it's your brother. But if it's a coworker and you never were dating, then you couldn't. So it's important to understand eligibility. you have to get the right type of order to do that. And I'll tell you this too, this is so important. I was involved in a case once, a few years back, and when that happened, the other party petitioned for the wrong type of order. That party petitioned for a sexual assault protection order, and a sexual assault protection order was wrong, and district court entered the wrong order. And so what ended up happening was that case ended up being litigated and going to multiple courts over 2 years. And it was all because the person got the wrong order and the court checked the wrong box. So you don't want that to happen. So be very clear and get some guidance on the type of protection order that you're getting. So let's talk about domestic violence protection orders. And again, I mentioned that this law has changed a little bit. Domestic violence protection orders are definitely going to be it depends on who you ask. Some people will tell you that they are, some people will tell you they're the easiest protection orders to get, and some will tell you they're the hardest. And what I mean by that is you have to prove whether domestic violence occurred and that you were a victim, and you have to fall within the definition of domestic violence. So I'll talk about that in a minute, but the standard on getting it, you don't have to prove beyond a reasonable doubt the way you would have to in a criminal case. So there's no other possibility beyond a reasonable doubt that this happened. That's a really high standard of proof. That's a criminal standard of proof. A domestic violence protection order is really, it's a lower standard of proof. I'm trying to think of the best way to explain this. I think the best thing to say is it's a preponderance standard, and that's a legal term. So I was trying to think of something easier to tell you. You have to prove that domestic violence was committed by a preponderance, or if you're defending on it, that you didn't commit it. You don't really have to prove anything. They have to prove it, but it has to be found that you committed it by a preponderance, which just means more likely than not. And that's not a super technical term, but it basically means it could be 51 to 49%. It could be just a little more likely than not. So it doesn't mean there might not be doubt that it happened, but it means there's a finding that more likely than not, this conduct occurred. And that's something that I think a lot of people really struggle with. They struggle with realizing, gee, but I told you all of these things, and I told you all these things that happened, and this shouldn't be believed. Well, it doesn't mean there can't be any doubt, but it does mean that you have to prove it more likely than not. So that's not a super technical standard, but I hope that helps. Melissa, are there any questions?
Yeah, can you actually repeat that word? Somebody's asking if you can repeat that legal word. Was it preponderance or another way of trying to?
Yeah, the preponderance standard is the standard that domestic violence protection orders are evaluated under. And that just means more likely than not. And that is that's very important, I think, for people to know. The standard is not super high. So, and I will also tell you too, that there are changes to the new law that went into effect last year, and the laws were changed significantly. So I'm going to talk about that now in a minute, because really you just have to prove that someone did something more likely than not. And that can be a really hard thing to defend on if you're falsely accused. On the other hand, if you really need protection, it's easier than trying to get a court to press criminal charges and waiting for that to happen to get that no contact order I talked about earlier. So while we're talking about domestic violence protection orders, let's talk about the changes. So
yeah, just really quick, Michelle, there were a couple other questions, and one of the questions is actually, are these the most updated laws for the protection orders that took effect? Were there new laws January 1st of this year?
Yeah, that's basically what I'm going to talk about now.
Great.
There were changes. I mean, specifically is the addition of what we call coercive control. So if anyone's heard that term, we're going to talk about that. Yeah, so basically to address a lot of the issues that people found with previous protection order statutes, the legislature simplified the process for getting a protection order. They wanted to make it easier for people to get. And part of this, this is a really hot button issue right now between lawyers and all kinds of people. The legislature standardized and simplified the process by expanding the legal definition of domestic violence to better reflect what they believe domestic violence looks like in our modern day. So it used to just be, domestic violence used to be under 2650-090. I've known the statute forever, and it used to just say physical harm, bodily injury, assault, or the infliction of, or the reasonable fear of infliction of physical harm, bodily injury, or assault. And that includes sexual assault or physical assault or stalking. So that's what it used to be. Now it's changed. Now the new definition of domestic violence is physical harm, bodily injury, assault, or the infliction of fear. This is also the same so far, of physical harm, bodily injury, assault. And the new part is non-consensual or non-consensual sexual conduct or non-consensual sexual penetration. Before it used to be sexual assault. Now it's any non-consensual sexual conduct. So that could be just touching, that could be conduct of potentially sexual harassment. So that's new. And then the other new part is coercive control. We'll talk about that more in a minute, or unlawful harassment. Those are all new parts. So the non-consensual sexual conduct or non-consensual sexual penetration, coercive control, and unlawful harassment. Those are all new. And then the part that was there before is the stalking of one intimate partner or household member or family member. So stalking was always there, but just adding this whole sexual conduct, coercive control, and unlawful harassment, those are all new, and they have really expanded. As you can tell, before it used to be either you hurt me, or I had a reason to think you were going to hurt me, or you stalked me. And now it's a lot more than that. So that's really important for people to know. You could be accused of some of these things just by saying something, because the legislature thinks that that's really what definition of DV looks like. And by expanding the definition of coercive control to include that and unlawful harassment, harassment was not part of the statute before either. The legislature recognizes, what they have said is they're recognizing the power and control an abuser has over their victim, and the power and control can still have extreme detrimental effects without physical harm. And I'm not here to say whether that expansion of the law is a good thing or not. I think it can help some people, and I think it can also be abused in other ways. So there's positives and negatives to every kind of a change, but this is a very expansive definition. It's far more than many other states even have. And it's very, very notable. And a lot of people wanted this to happen for a very long time. So let's talk about those changes in a little more detail. Intimate partner, it used to be the language. It used to be an intimate partner. So that would mean that you were sexually intimate with this person. Now it has been expanded to include anyone in a dating relationship over the age of 13. So additionally, this definition traditionally just found that anyone with a child in common was an intimate partner. Now it was modified. So that's modified. Family and household member is now expanded to include children of intimate parents or partners or parents. So it could be like a stepchild or stepbrother or stepsister, intimate partners, children, and legal guardians. So the definition of family and household member was expanded. Stalking. So stalking still references what stalking is, which is a criminal thing, but now it has its own definition as well under the protection order statute. And it's defined as a course of conduct involving repeated or continued contact, attempted contact, monitoring, tracking, surveillance, or disrupting harassment of an individual. And this has been modified to account for the fact that now there's a lot of tracking that goes on with people's phones or air tags or all kinds of technology considerations that we didn't necessarily have before. And the stalking definition has been expanded. And then let's talk about what's added. That's what was expanded. What was added? Coercive control is a big thing. And so what does that even mean? Coercive control is defined as the pattern of behavior that is designed to inflict physical, emotional, or psychological harm, preventing the survivor of coercive control from living freely. So this basically is kind of a really difficult definition for people to wrap their minds around. And here's some examples of coercive control: intimidating, controlling, or threatening behavior. And this also includes online. So that can be cyber harassment, whether it's text messages or emails or Instagram messages or whatever. So intimidating, controlling, and threatening behavior, which can include cyber harassment, causing, this is so hard to really just get into, and I wish we even had more time, but then also causing dependence, confinement, or isolation of the other party. So that again goes to the power and control situation where somebody might be controlling or isolating somebody or financially isolating them, because the next part of that would be depriving the survivor of basic necessities or committing financial exploitation. So if you cut someone off from all money and you're controlling them in that way, that could be coercive control. controlling or monitoring a person's movement, communication, or daily behavior of you or your kids. If someone's tracking you and you've said, I don't want to be on Find My Friends on my iPhone, and they don't care, they're doing it anyway, or they've put some other tracker, that would be an example of coercive control. So these are really major changes. And so all you really have to do, and I'm not saying that this should be treated as a cavalier thing, but all you really have to do is prove that more likely than not, the other party did some of these things. And how you prove it can be based on documentary evidence, if you have text messages or anything like that, or it can be by someone saying something happened. And this is something in protection order land that a lot of people don't understand. Someone testifies either by saying something or in a declaration that something happened. And then you testify and say it didn't happen. And then the court, nobody else was there that personally witnessed it or observed it. The court has to make a determination on who's more credible and who to believe. That happens in these cases because very often there might not be documentary evidence, and very often there might not be anybody else that was there. So that is something that I think is important for people to recognize. It's really what I would call an imperfect science. I want to talk briefly, though, about sexual assault protection orders. So we talked about how sexual conduct or penetration, can be part of a domestic violence protection order. So victims of sexual assault can now seek a sexual assault protection order. This was there before, but the relationship component isn't, you don't necessarily have to have that family relationship. If you were sexually assaulted by a random stranger, you could get a sexual assault protection order. This order is really specifically designed to protect individuals who experience sexual assault or abuse. So it provides similar protection as a domestic violence protection order, but it's specific to sexual assault. And it doesn't have to be that you had a dating relationship. You could have never seen this person before and they could have assaulted you, or it could be a coworker or whatever it might be. You could get a sexual assault protection order to protect you. And then the last one that I really want to touch on is an anti-harassment protection order. So an anti-harassment protection order is available to victims of harassment or stalking, regardless of the relationship. Again, you don't have to have that relationship to get a protection order. Before the law changed, if you had harassment and not domestic violence, you couldn't get the domestic violence protection order, even if it was your wife or husband or mom or something. You had to get the anti-harassment. Now you can get that protection order if it's a family member, because that's recognized as part of domestic violence. But if it's not a family member, you can go ahead and get an anti-harassment protection order. So victims of harassment or stalking, regardless of the relationship, they can go in and seek this order. The whole point of an anti-harassment order is to prevent unwanted conduct, communication, or behavior that causes somebody fear or distress. So it's a good option for a lot of people if they have a neighbor dispute. You see these kinds of orders, a coworker, or just somebody that goes to a certain place you do that is doing something to you. So that's kind of what these types of orders are. I also think it's important to talk about just the perspective of what it's like to be someone who was accused of something and has one of these orders enter, and what the ramifications of that can be. So I'm going to talk about that briefly, and then I'd like to see, again, I think there's probably a couple more questions.
Yeah, there's a handful of questions when you're ready.
All right, I'm just going to talk about this briefly, and then I'll take those questions. If you have a protection order, if someone's got a temporary order against you and you have a return date for a protection order, you need to take it really seriously. So what a protection order is a civil order. It's not a criminal charge. However, if you are someone that has a family law case or you have children, if a protection order is entered against you, it could be a basis to have restrictions in your parenting plan. It could affect your parenting. Are you going to be arrested for having a protection order entered? No. But if you violate it, that's a criminal charge. So it puts you at risk for that. If you are traveling, whether it's crossing the border to Canada, or you are trying to get approved for TSA pre-check, or you're coming in on global entry or something from traveling, you're probably going to be stopped if you have a protection order. And that's a normal thing that happens. You might be, if there's a protection order against you and you're driving in the car, and let's say you have a male in the car that looks a certain way and a police officer runs your plate and sees somebody in the car, they're going to pull you over to make sure it's not that person that's the restrained party. So there's things that go along with it, from really extreme consequences like having it affect your parenting plan to not so extreme like a little bit of trouble at the airport. An important thing also to note before I take these questions is that protection orders can be renewed. So once you get one, they can be renewed, and the burden to renew them is not very high. We can talk about that another time. A no contact order or a restraining order is going to expire at a certain period of time. A domestic violence protection order or another protection order is going to expire, but it can be renewed. So it's a more powerful order from that perspective. Go ahead, Melissa.
Yeah, a number of the questions that we have are pertaining to coercive control.
I can see why.
One question kind of having to do with, sounds like somebody has a protection order granted on the basis of coercive control against them, and feeling kind of like, why is this based off her feelings and what she thinks rather than the facts that I'm producing? You kind of talked a little bit about that, but can you talk a little bit about how, again, how coercive control is reports, right? I mean, it's basically somebody's reporting something. They're also asking kind of, what can I do other than just wait for the year? Make your motion for revision? Is there something else to do?
Okay, let's talk about that procedural part of this. And this is never something anyone wants to hear. And this is why I told you, if an order is going to enter, give the best defense that you can ASAP, because there's not a lot you can do. You don't want to hear that. But and I have extensive experience terminating protection orders, but you're not going to do it within a year. So let me tell you that. And protection orders sometimes are for a year, sometimes they're for 2 years, sometimes they're for 5 years, sometimes they're for 10 years, sometimes they're lifetime orders. So there's a lot of different things that can happen. Or someone can enter an order for a year and then they go back to renew it and you can get it renewed for longer. So anyway, a lot of considerations there. Here's the procedural part of this that you should understand. If an order is entered against you, like let's say an order is entered against you, then what needs to happen is you have 10 days from the time that order enters, 10 calendar days, not 10 court days. Yes, the weekend counts. You have 10 days from that time to seek revision. And when I'll tell you what revision is, usually a protection order is entered by a court commissioner. It's very rarely entered by a judge because commissioners hear these calendars on the lower level to free up time for the judges to hear trial cases. So if you have a protection order entered by a commissioner, you have a right to revision, and revision is the review of your order and that decision by an elected official who is a sitting judge. You only have 10 days. If you didn't do it within 10 days, you're not getting it. And you have to properly note that motion for revision with a certain amount of time. You have to provide the court with certain things depending on what county you're in. It's a technical process and you don't have a lot of time to waste. Some cases you need to order a transcript. There's just different things you need to do. So you should get some help with that within those 10 days. You can also seek reconsideration. So there's reconsideration and revision. You have 10 days for either of them. And so what you would do in that circumstance is file a motion for reconsideration and tell the court why they should reconsider. Usually people aren't going to reconsider themselves unless there's an error they might have overlooked. But most of the time, revision is what you need to do. And that's not arguing it again. It's providing the same information and basically having them review your decision, sometimes with oral arguments, sometimes without. If you're outside of that 10 days, you're not getting your order dropped. You lost your chance to have it reviewed if a final order has entered. If a temporary order has entered, we can talk about that in a minute. But if a final order is entered and it's within the first year or two, it's not going to be worth it for you to bring a motion to modify or terminate that protection order unless there's a really big change in circumstances. But essentially, you're going to have to wait. And then if somebody goes to renew it, you're going to have to defend on that renewal. And it would be very wise if you're subject to a permanent protection order of when I say permanent, I mean more than the temporary. If you have treatment or something that was ordered for you to do, you need to do it, because if you're not done with it, then there's no way the order is not going to be renewed if someone asks. So it's really important that you take that seriously. In other circumstances where I've had cases where someone's facing a 10-year protection order or a lifetime order, there's very specific arguments that can be made, and there's a process you can follow to try to end a protection order early. But that's never going to happen in the first couple of years. It wouldn't be worth your time or money to try to do it. So I hope that's helpful.
Yeah, and somebody did actually ask, can you have a permanent protection order removed? So
you can. It's not easy to do, and there is specific case law and specific factors that you have to meet, but I've actually had it done. So it can be done, but it's not easy, and usually neither is the imposition of a permanent lifetime order is not something that's taken lightly. So undoing it, again, is not, but there is case law and there are ways to approach that, or at least try.
Several other questions. As when you were talking about coercive control, someone asked, does this include when an alcoholic is verbally abusive and controlling?
Maybe, probably. And here's the thing, like, I want to really clear about this. Everybody has, if you haven't, then you're a better person than me, but everybody has lost their temper at some point. Everybody has said something they wish they shouldn't have to someone in the heat of a moment. Everyone has sent a text they wish they hadn't, or whatever. This isn't like that. This isn't like an isolated one-time thing, unless your isolated one-time thing was like really threatening somebody or saying something terrible. But if this is just like, fighting with someone, this isn't that. This is a pattern of behavior and conduct that is controlling, isolating, whether it's financially or emotionally, and causing that kind of harm. So yeah, I mean, in an relationship with an alcoholic, that very well could be the case, but it's going to be very fact specific. So you're going to want to review your specific situation with someone.
Also on coercive control, what if the other party is using a shared child to somehow control or mentally harm the other party?
Yeah, I mean, that's a big part of it. And that's why the definition and the way that the legislature has expanded does include, following your kid, using your kid as a mechanism for control. And also in family law cases too, that kind of makes me think about abusive use of conflict might be a term you may have heard. That's outside of the protection order context, but you can have restrictions in your parenting plan or engaging in an abusive use of control by using a child in conflict over every little thing. So anyway, yes, that does matter, and it can play into coercive control in the protection order context.
Another question about whether there's any indications of gender bias with coercive control. Feeling like the basis kind of seems very easy to abuse right here.
Yeah, people ask me about gender bias all the time, and I don't mean to make light of it. I really don't, but I'll be honest with you. A lot of men too, this seems to be a thing on social media as well. Men think the court system's biased against them. And I'm not saying in some counties or places that might not be the case, but I've represented both sides many times. I've represented plenty of women that have gotten slapped with protection orders, and plenty of women that have gotten called out for controlling and abusive behavior. So it's not, I think we're also fortunate. I'm sitting here in my office in Seattle, and I'm in King County, and King County is a court that is, in my experience in practicing here for quite a long time, is more progressive than certain other counties, as far as many dads are given primary custody. Many parents are on 50-50 schedules. Many moms are, or just women are found to have violated
You think
law.
that's less so in Spokane?
I can't tell you about that in Spokane. Spokane's more conservative than here. So if I had a choice of where to bring a case and I was a man, I'd rather bring it in King than Spokane. But I've had some cases in Spokane. I think we might have a couple there right now, but I don't live there and I don't know the community as well, but I know it's more conservative. Same thing like with Pierce County, is a little more conservative than King. But I do think in general, there is no presumption for a mom, and there's no presumption for a woman in Washington law. I'm going to tell you this too, and this might be something that's hard for people to hear, but you could go to King County, Snohomish County, any county you want, Spokane County, you can go into 5 different courtrooms with the same exact parties and set of facts, and you could get 5 different outcomes. And the amount of discretion that's given in these cases, because it's not a black and white area, all 5 of those different outcomes would all somehow be right. So you don't know what's going to happen when you're in front of a court, which is another reason why, if you're facing a protection order, get help right away. I can't tell you the number of times I've had someone facing a temporary order, and I've been able to negotiate a resolution outside of court, and not even have to have you be in that situation. So you really want to talk to somebody and mitigate your risk before you go into one of those different courtrooms and get a different answer than you might get down the hall or in a different county. So I don't know if that's helpful, but that's reality.
Thank you. Yeah. Number of other questions. How does someone get their DVPO sealed? It says the opposing party is an ex-police officer who got fired for DV. How could they have it sealed?
They're not getting it sealed. If they would like to, good luck. In Washington, especially There's case law, and they're called the Ishikawa factors for sealing. It became very difficult to seal court records. And the reason why is because, and there's a test for it, but basically, especially not a domestic violence protection order, you're not getting that sealed. If you can show that it's actually harmed you, the records have harmed you, that there's been a showing that the public interest is outweighed by your personal privacy and protection, you might be able to get it sealed. But that's not going to happen in a protection order case, because if you have a finding of DV, it's in the court will believe that it's in the public interest to have that out there. You might be able to get something sealed in a different context, but it's difficult to seal in Washington. And I would bet you dollars to donuts that no one's getting a protection order sealed, absent like really extreme circumstances. And I don't actually know what they would be.
Okay. Somebody's asking, what if you don't get served and the court schedules you to be heard after four months after they've served you? I'm confused about the question. It says they got their motion to reconsider approved after 4 months because they weren't served. Is there issues about maybe being served or not being served, and how that might come into play?
Protection order is something that I would call being served with an initial protection order, or an order to come to court to defend on a protection order if a temporary one was issued, is what I would call original. It's an original service to process situation where you have to actually be served with it personally. And if you're not, or unless somebody goes and tries to serve you and then gets an order for service by mail, that could happen too. But if you're not, and that's not what's happening, then the order is not effective until you're served. So I don't know what happened in your situation, but yes, just in general, you have to be personally served. So if you filed a reconsideration, like if an order entered and somebody lied about serving you, and so they entered the order, that's the thing too, the court has to check and make sure you were served before they enter an order. So if you sought reconsideration and said, hey, I actually wasn't served, this was a mistake, then maybe the court granted it and said, yep, you weren't served, order's thrown out. Then they could try again if they wanted, but yeah.
Lots of good questions.
Yeah.
So if there's no violence in my history and I've not violated the protection order, how could it be renewed? Or could it be renewed?
Easily. There's no requirement that if here's the thing, you're saying there's no violence in your history, and I'm not saying you're right or wrong, I don't know you, but the court found that there was, or there wouldn't have been an order entered. So to renew, I'll tell you what the burden is on renewal. I told you already, it's a preponderance standard. Somebody has to prove more likely than not. The petitioner has to prove this happened more likely than not, right?
This was one that was approved based on coercive control.
Okay. On a renewal, I'll tell you what I think in a minute, but on a renewal, the burden shifts. The burden's no longer on the petitioner. The burden's on you. The Washington law flips the burden to the restrained party to show that they're no longer likely to commit domestic violence. So you have to show that you're no longer likely to engage in coercive control or whatever the finding was. Proving you won't do something is really hard. And so that's why I said earlier, if you're ordered to do any kind of treatment, do it, because you can show, look, I'm rehabilitated, I won't do it again. You can't go in there and be like, I never did it in the first place, or they'll automatically say, like, you're not taking accountability. This already was found. So it's very difficult to prove you won't do something, but the burden's on you. So if you do things like say, hey, I went and I took this positive communication class. I just had a client do this a while ago who had a coercive control DV enter. And so she's going to take some classes. So when it comes up for renewal, if it does, she can be like, these are the things I've done to show you I'm not likely to do this again. I've also engaged with a therapist, and my therapist is going to write a report saying we really worked on these issues, like different things. You have to prove it, though, that you're not likely to do it again. And it can be really hard to prove you're not going to do something. And a lot of the time, too, if the court thinks after looking at what happened originally, like I've had some protection orders where it's been really extreme conduct, and the court's like, you don't have to violate again. It doesn't say that you're going to violate again, but the court says this was pretty bad and we need to wait a little bit longer than a year before I would agree to not renew it. That's good enough, because they're going to think you're not rehabilitated by now. So renewal is a difficult situation because the burden shifts to the protected party. I'm sorry, away from the protected party to the restrained party, if that makes sense.
Yeah, thank you. And we talked about abusive or coercive control using kids. How about if they're using pets? Has that ever been a thing? Can you imagine that?
It could be, like, if I don't know the specifics of your situation, but if someone is, doing something or of animal abuse, or restricting an animal's access to food, or doing something, any kind of household dynamic like that, would definitely be something that was looked at. But again, it would be really fact specific. So if you're thinking about getting an order, you should review your circumstances with somebody to help you prepare your petition and explain the factual situation. What you really want to do is you want to say, here's a little law school overview for you. You want to say, what's the issue? Did this occur and should I be protected? What's the rule? It's going to be the statute that defines domestic violence. What's going to be the application, how that issue and that rule are applied to my case. You need to make a strong argument showing how that rule applies to my case and the conduct. And then what's the conclusion? It's called IRAC, issue, rule, application, conclusion. So you need someone to help you put that together, especially when it comes to a coercive control case, whether you're defending on it. Maybe you're the one saying, look, here's the rule and it doesn't apply, right? So you need to be really careful, but that's what the court is looking for. It's not just enough to go in there and be like, I didn't do it. You want to show why your conduct did it, or why that person's conduct did qualify, or why it didn't. So, yeah.
Okay. Now, this question's probably, it's a bit too fact specific. We can't give you too much information here that's specific to your case, but I'll try to see if I can generalize. They're saying that their ex often kind of refuses to give black and white answers related to child rearing and will kind of hold responses about the child hostage or delay responding and kind of, you know.
That doesn't sound like coercive control, or that sounds to me like maybe abuse of conflict in a parenting plan situation, or just high conflict parenting. And maybe you need a parenting coach, or maybe you need to use our family wizard, or maybe any number of things. But a court's not, this is another thing for you to know. The court is, if you have a parenting plan, these are definite parenting issues. And that happens in a lot of cases. Doesn't make it okay, but a court's going to be like, that's not a reason for a finding of DV. That's something you need to deal with in the family law context. That happens a lot where people want to get an order, or they think it should be this or that. But anytime there's a family law case, the court, again, and it goes back to what I said earlier, the finding of DV can have very serious implications in a parenting plan. So if it can be handled in the family law context, the court's going to want that to happen, because it's not going to want to impede a parent-child relationship unnecessarily by making that finding.
It sounds like in this case, they're saying there is a history of DV and a no contact order that's now extinguished, and that this person's trying to keep conversation on the child, but the other person holds the answers hostage and makes it difficult. So maybe, would it be a different story if there's a history of DV and protection orders?
I mean, maybe, but you should already have restrictions in your parenting plan. If you don't, you're not going to get them now if you agreed not to have them. But you could deal with, like, this sounds like a high conflict situation. You could deal with it with trying to change the parameters for contact in your parenting plan and being like, look, I have this history with this person. I need to limit contact to our family wizard, which is a program, or talking parents. I need to limit, you might need a tighter parenting plan in a situation like that. And you might want to talk to somebody about doing even a minor modification for that.
Yeah.
That sounds probably like what you're dealing with. Are there any more? There's not,
yeah.
I'll wrap up with the summary. No?
One more question here. Let's just ask one more question. How do you go about trying to get a DVPO later on after being denied for a final order?
You're not going to get one unless something else happened.
Right. They're saying if they got a second denial, it could be bad, but also it seems like waiting for something bad to happen seems like a weird
Well,
kind
I'll
of.
tell you one thing, that if you already had these issues, had this come up not that long ago with somebody where I had to explain this, and then you don't want to hear it. And I understand why. Can you get an order denied when you should have got it granted? Yes. Does it happen every day? Yes. Is the process perfect? No. But if you get an order denied, then the court has already ruled on what we call on the merits of the order. They've already heard these facts, they've already heard what happened, and it was denied. There is essentially a doctrine called res judicata, which means the finality of litigation. So you cannot go back, and we call it, I'll be like, motion to deny that because it's reapplication of the same facts. You cannot make a reapplication on the same facts. It's done. If something else happens, then you could go back and you can be like, hey, you didn't listen to me before, and you can mention it all again. And this happened. But if nothing else happened, the court, even if they want to, because like I said, you could go into 5 different courts, get 5 different answers. Maybe somebody found it wasn't DV and the person next door would have, but they don't have the legal authority to do anything about it. It's already been decided on the merits. The decision's already final, and you are probably going to get slammed and hit with attorney fees for making a reapplication on the same facts. So if something else happens, then yes, but the court's already decided that they don't think there's a basis for a finding, whether that's right or wrong. Don't go and try to just do it again. Don't try for a do-over with a different judge, because you will get slapped down and probably paying attorney fees. That's a hard thing to hear, because it doesn't mean that a denial was right. And, you know, that's just sometimes what happens. So anyway,
Thank you.
anything else?
Yes, so I'm going to put up contact slides here at the end. Somebody's asking about contact information, so I'll be sure that we put a contact slide up here. One last question. If I have a police report indicating DV that's 2 years old, can I still get an order for continuing harassment?
All right, I'm glad someone asked about this. This is actually
The last one, because we do have to wrap up.
All right, then we'll wrap up. Yes, but here's the thing for you to know. There's no time bar in the protection order statute, and that's on purpose. The reason why there's no time bar is literally because the legislature's intent was to make this easier for people that didn't report. A lot of people don't report DV and sexual assault and things like that when it happens because of the dynamics of, you know, relationships. And so you might come forward and report it later. So there's nothing saying that you can't report something 2 years later, whether it's harassment or DV. There's nothing saying you can't get an order, but the practical experience is this. If you waited 2 years and you still had contact with this person during that time and you live with them or you were in a relationship with them and you didn't, and like after that, then it's going to be a question of credibility where they're going to say, well, if this, you're saying this happened 2 years ago, but then you did X, Y, Z, probably not going to enter the order. Or a situation where nothing else has happened and it's been 2 years, they're probably going to say, you know, we're not saying it didn't happen, but we can't make a preponderance decision because it's been a while and maybe we don't have as much information as we need. So the further away it is in time, unless that acts were continual, the less likely in my experience it is to enter. But there's nothing saying you can't seek it. I would just take caution if you do. Okay.
Yeah.
I'll just wrap up by saying it's important for you to know that these orders are meant, and this is really important, okay? Anybody listening, this is my personal perspective, but I'm telling you this because it's true. Protection orders in particular can be used, they're supposed to be used as a shield, to shield somebody from violence or abuse or harassment, right? But very often they are used as a sword to come at somebody, to gain a leg up in a custody battle, to make somebody's life hell, to do all of those things. So while I think they should be used as a shield, and that's very important, it's important for you to know too that just because someone makes that allegation doesn't make it true. And they might be trying to use it as a sword against you. And if they are, you should get help defending yourself, because once you have that finding of domestic violence, it can create implications where you can't go on your kid's field trip later because someone did this. You can't get pre-check. You're going to get pulled over. You're going to have restrictions. It's a serious situation, even though it's not criminal. And so if you need protection, you should get it and use it as a shield. That's what it's there for. But if you're looking to retaliate against somebody, or you're the person being retaliated against for the wrong reasons, and they're using it as a sword, you should defend yourself. So I hope this was helpful. I know we didn't really go back and talk much about NCOs or restraining orders, but we did touch on those a little bit. So if you have more questions about those, feel free to reach out. Thank you very much and have a nice day.
Yeah, and I just want to also add, a couple of people were asking about client capacity and things like that. Michelle's firm is always taking consultations, so please do contact them if you're interested in setting up a consultation. If you're interested in counseling services, if you are either somebody who's dealing with a controlling person and you need protection, or if you're having something entered against you and it feels really unfair or manipulative, probably could use some emotional support. And feel free to reach out to me. And I definitely do free consultations for my therapy practice, and we can talk about how I might be able to be supportive. Get support, get legal support, get emotional support, make sure that you're, using all of your resources in order to shield against whatever it is that you're dealing with.
Yeah, I will say, if somebody's asking about retaining or services, I handle these matters. I also have a team of 7 other attorneys. Everybody in our office handles domestic violence. Our office deals with difficult, sticky situations, and a lot of the time that's domestic violence. So our office does deal with domestic violence protection orders, domestic violence in the context of a family law case. Sometimes I still deal with domestic violence in a criminal case, especially if there's a family law case going on at the same time. But that's kind of what we do. Like, your messiest, worst situation is kind of our everyday. So that's what we do here. And we're happy to talk to you about it. I hope you don't need us, but if you do, reach out. And what Melissa said is so important. If you're going through a situation like this, whether you're the protected party or whether you're the restrained party even, having therapeutic support is so critical. It's critical for you and your own well-being. It's also critical for your legal case. So that's another thing you should know. Showing that you're taking care of yourself so you can take care of your kids, or showing that you're not a danger and you're really being proactive is so important. So I can't stress that enough. Anyway, I wish you the best and have a nice day. We hope to talk to some of you later.
Thanks, everyone. Take care.